You're tuned in to Agriculture Today, and we start our Wednesday show with some information about agricultural law and taxation. And to talk about it today, we're joined by K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Thanks for having me, Shelby.
Roger, we've been talking about things that happened in 2023, but now looking to what might be happening in 2024. And the first one, talking about a takings case. And in this instance, what is a taking?
Well, a taking, it involves the government, whether it's state or federal, and here we're talking about a federal case. The government has the right to take your property from you, but the Constitution says if the government does that, they have to pay you for it. And so that's in the Fifth Amendment to the Constitution.
And a case that really shows why that rule is important.
Yeah, we have a case out of Texas, and this case is presently before the U.S. Supreme Court. And this involves a family that's farmed the same land for over 100 years in South Texas along the Gulf of Mexico. And what happened here was that the state came in and renovated a highway and changed the surface water drainage. And the farm had never had a problem with drainage in the past, never had a problem with flooding until that state highway project. And in essence, the renovation turned that highway into a dam, and when tropical storms would occur, the water no longer drained into the Gulf of Mexico. The farm was left flooded for days. It destroyed crops, killed their cattle, and created just an absolute disaster for them.
Why is the outcome of this something that could be really important to agriculture?
Well, they sued the state for a taking, and the lower court said that you can't sue because Texas doesn't have a statute that allows you to sue. The takings has to be brought by the state. I find that somewhat remarkable. The case law goes the other way on that. There is some split of authority on that, but you don't need a statute because you have a constitution. The constitutional right that the landowner has is to assert a taking or an inverse condemnation, whatever the case might be. And I think the Supreme Court will reverse this. I don't know that it will be unanimous. I'm hoping that it will be unanimous. But the importance for agriculture is that when the government comes in and it condemns some of your property to expand a road, for example, or whatever project that the state or the federal government wants to use for a public purpose, they have to pay you for it under the Fifth Amendment. And that's the principle that we're hoping that the U.S. Supreme Court will affirm again. And that's important for agriculture because land is the number one asset. We don't produce things if we don't have land.
And Roger, something else you're keeping an eye on for 2024, a case involving taxing wealth.
Right. This is a case that, again, is before the U.S. Supreme Court, and it involves the situation of whether income tax can be imposed without a taxable event, without any type of sale or other disposition that would otherwise trigger tax. And what happened here is a corporation over in India that is known as a controlled corporation. It's a controlled foreign corporation, so a CFC as we call it. Meaning that most of the stock is owned by people in the United States or residents or citizens of the United States. And there was a law that was passed as part of the 2017 Tax Act that really created a one-time, I'll call it a repatriation tax, although it's technically something different, that said, all right, if your wealth, your value of your investment, your wealth in this instance, your investment goes up in this corporation, then we're going to tax that on a one-time basis, and we're going to pull that home. And it was deemed to be a revenue raiser in the 2017 Act to pay for a lot of the other tax cuts in that provision. And so the stock investment in this company by these people went up sufficient enough to trigger a $15,000 tax bill. Now, mind you, they didn't sell any of their stock. They get a bill from the Treasury for $15,000. This is your tax obligation. And they paid it, but now they're challenging that. So they went to court to challenge it to get a refund back, and they've lost so far, and it's before the U.S. Supreme Court. Now, I think this one is key because if the court says that the government can tax your wealth without a tax event, then that brings us back to Senator Elizabeth Warren that has pushed for a number of years for a tax on wealth. And that would seem to light a fire under that and perhaps reinvigorate that attempt to try to tax wealth without a tax event. That's important for farmers and ranchers. What if you get a bill because your land value went up, for example? Can they do that? Well, we'll see what the Supreme Court says. The other issue that I'm concerned about here is if we can tax wealth, then that would seem to indicate that the Congress would be okay and might feel empowered to eliminate the step-up basis rule at death. And so instead of waiting until your heirs sell the property that they inherit and then taxing it at that time, we would impose the tax upon death before they receive the property, even though there hasn't been a taxable event. So this case is how the court decides this. And I'm not sure they're going to go clearly one side or the other. They may try to thread a needle here, and I worry about that. But this one has significant implications for agricultural producers.
So really not even money changing hands, just if something becomes more value, you have to pay taxes on it.
That's exactly what this case is about.
Another case for us to talk about that's taking place in 2024, Chevron Deference, and not a fashion statement here.
No, the Chevron case goes back into the 1980s. This case is over 40 years old, or right at 40 years old now. And basically what the Supreme Court said was when we have an administrative agency that makes a regulation based on a statute, we're going to go with what their interpretation of that existing statute is, unless it is just completely out of bounds. Any reasonable interpretation we're going to uphold, and that's known as deference, Chevron deference. Chevron is the name of the case, and that's where the deference language or where the deference principle comes from that we still operate under today in large extent. Now, there have been a couple of cases in recent years where the Supreme Court has chipped away at that, but now we have two cases on the same issue in front of the Supreme Court involving the fishing industry, where deference it gives the court the opportunity to change the deferential standard substantially and maybe perhaps move away from Chevron deference. Now, that's important to us in agriculture because farmers and ranchers often get into administrative disputes with USDA or a branch of USDA, and they often lose those cases because if the court thinks that the administrative agency has made a reasonable interpretation of whatever rule is at stake, a reasonable interpretation of the overlying statute, then the administrative agency will win. If the court changes the deferential standard and lowers that standard, what that might mean then is that farmers and ranchers will have a greater likelihood of prevailing in these administrative disputes with federal government administrative agencies.
So not just an automatic shutdown of if they think something's wrong with that agency.
Yeah, it's not an automatic pass that the agency is going to get, which is often the case, and that's how farmers and ranchers feel about it. So that deferential case is real big. So we've got 3 cases before the U.S. Supreme Court that will be decided in 2024 that are going to bear on agriculture substantially.
One more thing for us to talk about today that's recently come up in this past week involving dicamba.
Yeah, here we are back again in the courts with dicamba, and of course this has to do with a court invalidating the registrations for dicamba, 3 different registrations for dicamba products. And this happened back in 2020. The U.S. Court of Appeals for the Ninth Circuit did the same thing, and EPA went back to the drawing table and kind of went through the process again and said that they had made changes, and the court disagreed with that and said, well, if you didn't go through the administrative process that is required when you register a pesticide. You have to follow the Administrative Procedures Act. You have to open things up for public notice and comment. You have to hold a hearing. And that's the same rule that's there under the federal pesticide law, FIFRA, as well as the Endangered Species Act, the court said. Now, that's a little bit unique in the case, the ESA angle on this. But they failed to do that, and so the court had no alternative other than to invalidate the registrations and tell EPA go back to the drawing board, go back through the administrative process to properly register these pesticides. Now, the problem we've got is the timing on this. The timing could not be worse. And I've already been flooded with dozens of emails and calls from cotton and soybean producers, primarily cotton producers down in South Texas, that are ready to roll out. And several of these have purchased high 6-figure numbers of prepaid dicamba-tolerant seeds, which they cannot use dicamba on right now. There are alternatives, but we're going to see we could see even a worse problem with drift with the alternatives to the dicamba products. So the alternative here for the court would be, or maybe not an alternative, but what the court could do is stay their order to get us through this crop season. I don't know if they'll do that. But I think we've got a lot of people that are kind of in a holding pattern waiting on the court to say that they're going to do that or tell us they're not going to do that.
Roger, at this point, is it just the ag producers waiting to see what the courts decide?
As of right now, that's where we're at. We may be in a different spot a week from now, but there are motions before the court to stay that order. I'm sure there'll be an appeal of it, but the legal process takes time. Any appeal is not going to solve the problem for this growing season. It takes time to get through the legal process. So it's up to the district court judge to determine whether they're going to stay their order or not.
Roger, I appreciate you taking the time to join us today and share with us some things that you might want to keep your eye on in 2024.
My pleasure. Thank you.
That was Kansas State University and Washburn Law Professor Roger McEowen. You can read more on these topics from his recent article, The Big Issues for 2024. There are a few different places you can find it. You can do so by going to washburnlaw.edu/WALTR, or you can also find it by going to agmanager.info. And of course, I will link it also in today's show notes on agtoday.net.